Good morning, friends. Today I will discuss with you Civil Appeal number 3155 of 2023 in the Supreme Court of India. This appeal is related to feeling aggrieved and dissatisfied with the impugned judgment and orders passed by the High Court of Judicature at Patna in LPS. The respective original rate petitioners, who are work charge employees, whose services were subsequently regularized as per work charge establishment revised service conditions, repealing rule 2013, have preferred the present appeal. The issue involved in the present appeal is with respect to the counting of the period of work charge services for the purpose of computing pensionary benefits and the length of pensionable service. A large bench of the High Court, by impugned judgment and order, while upholding Rule 5, Subclause 5 of the Rule 2013, has held that the period spent in the work charge establishment would be counted only to the extent of the shortfall in the qualifying period of service for grant of pension, which shall be made up by adding that period spent under the work charge establishment, and the entire period spent under the work charge establishment would not be taken into account. The respective original writ petitioner were initially appointed and working under the work charge establishment as work charge. The state government came out with the rules from time to time to regularize the service of the work charge employees, and also how the work charge service to be counted considered. Lastly, the state government framed the rules 2013, under which the services of the original writ petitioners came to be regularized. One of the clauses, namely Clause 5, Subclause 5 of the above rules of 2013, provided that old pension scheme will be applicable on these personnel. It further provided that granting the pension and gratuity benefits will be calculated with the recognition of regular service of 1 year for the work charge service of every 5 years. And in spite of this, if the minimum pension paid service is not completed for pension acceptance under the old pension, the benefit of the pension will be given by adding minimum service to that extent. Though the original writ petitions were held to be entitled to the pension by taking into account the service rendered as work charge for the purpose of qualifying period of service for grant of pension, they challenged Rule 5, Subclause 5 of the Rule 2013 to the extent it provided that for the purpose of counting of pension, regular service of 1 year for the work charge service of every 5 years shall be taken into consideration. According to the writ petitioner, the entire service rendered as work charge in the work charge establishment is required to be counted or considered for the purpose of pension. Now, there were differences of opinion in the two divisional bench judgments with respect to counting of period of work charge services for the purpose of computing pensionary benefits and length of pensionable service. Therefore, the matter was referred to the larger bench. The larger bench, by impugned judgment and order, has answered the reference in the following terms. With respect to addition of number of years of service rendered in a work charge tenure to the service under regular establishment for the purpose of making the service of such regular employees pensionable, There is practically no substantial difference in the pronouncement of the two divisional benches in the case of Sheila Devi and Binod Kumar. For the purpose of pension, only such period from the birth charge tenure would be added for making the service of an employee which has been regularized to qualify for pension. While adding such period of work charge tenure, the modus would be of granting counting 1 year for every 5 years of service rendered under the work charge establishment. If that also leaves some shortfall, then further number of years of work charge tenure can be taken added for making the service of the employee pensionable. For the purpose of giving benefit to the employee for promotion on a selection grade and time-bound promotion, the entire period of service rendered as work charge employee can be counted. The rules and circulars of 2013 are valid as has been held in Binod Kumar. The rules and circular of 2013 are applicable to such work charge employees who have been appointed after 22nd of October 1984 and prior to 11th of December 1990. The learned counsel, appearing on behalf of the appellants, has submitted that in fact the respective appellants rendered service as work charge for approximately more than 30 to 35 years. It is submitted that they were also granted other benefits like assured promotion scheme while working as work charge under the work charge establishment. It is submitted that their earlier service rendered as work charge employees shall not be wiped out and or at least cannot be ignored for the purpose of pension. It is further submitted that respective appellants were as such appointed not on a particular project, but the appointment was for a work which was regular and periodically in nature for a monthly salary, and they were working in the government department. It is further submitted that their services were not qualitatively different from the regular employees. It is further submitted that it was unfair on the part of state government to take work from them for period depriving them of their due emoluments. It is submitted that all the appellants were appointed after their names were called from the employment exchange. It is submitted that as observed and held by this court in the case of Prem Singh versus State of Uttar Pradesh 2019, the services rendered as birth charge is to be counted for pensionary benefits. Learned counsel, appearing on behalf of the appellants, has heavily relied upon the paragraph 29, 30, 31, 32, and 36 of the above decision. Learned counsel, appearing on behalf of the state, while opposing the present appeals, had submitted that, in fact, taking into consideration the fact that despite having worked for a longer period as work charge, therefore, when they were regularized and they were found short of qualifying service for pension, and on that ground, they may not be denied the pension solely on the ground that they have not completed the qualifying service for pension. A council decision has been taken by the state in favor of such employees, providing that for the purpose of qualifying service, the service rendered as work charge is to be counted to make them eligible for pension only. It is submitted that their services rendered as work charge cannot be counted for the purpose of actual pension. Otherwise, there shall not be any difference between the regular employee and the work charge employee. It is submitted that till the birth charge employee is regularized, he continues to be birth charge employee. It is submitted that the larger bench of the High Court has rightly observed and held that for the purpose of pension, only such period from the birth charge tenure would be added for making the service of employee to qualify him for pension, and while adding such period of birth charge tenure, the modus operandi for counting would be 1 year for every 5 years of service rendered under birth charge establishment, and if that also leaves some shortfall, then further number of years of birth charge tenure can be taken added for making the service of employee pensionable. It is submitted therefore the High Court has rightly upheld the Wires of Rule 2013. It is submitted that in so far as the reliance placed upon the decision of this court in the case of Prem Singh relied upon on behalf of the appellant is concerned, it is submitted that the said decision shall not be applicable at all, as the reliance placed upon the said decision is absolutely misplaced. It is further submitted that in the said decision, this Honorable Court was considering Rule 3 Subclause 8 of the UP Retirement Benefits Rules 1961, which specifically provided that the period of service in a birth charge establishment shall not be counted for qualifying service for pension. It is submitted that the Honorable Court read down the said provision and has observed and held that service rendered as a birth charge shall have to counted as qualifying service for pension. It is further submitted that while considering the validity of Rule 3 Subclause 8 of the said rule, the Honorable Court observed that after rendering the service for a number of years, they cannot be denied the pension on the ground that they have not rendered the qualifying service for pension, and that the birth charge service can be counted as qualifying service for pension. It is submitted that while considering the validity of Rule 3 Subclause 8 of the above said rules and denying total work charge service to be counted as qualifying service or pension, this Honorable Court has observed and held that it will be unfair, unjust, and impermissible to deny them the pension, and to that it is observed and held that the birth charge service can be counted as qualifying service for pension. It is submitted that in the said decision, the Honorable Court has not observed and held that their entire service rendered as a birth charge shall be considered for the purpose of counting of the pension. It is submitted that the said decision shall be restricted to the period of service rendered as birth charge to be counted as qualifying service for pension. The short question which is posed for consideration of this court is whether the entire service rendered as birth charge under the birth charge statute shall have to counted and or considered for the determination of amount of pension after the birth charge employee are regularized under the rule 2013. So it is required to be noted that the respective appellants were working as birth charge under the birth charge establishment in the state. Their services have been regularized under the rules 2013, and the follow-up notification of the Finance Department White Circular number 10710 dated 17th October 2013, Rule 5B of the circular reads as under. 5 Subclause 5 Old Pension Rule shall be applied on the employee. The benefit, pension, and gratuity shall be counted by giving 1 year advantage against the 5 year service as birth charge employee. Even then, if the minimum requirement of 10 years of service for pension is not met under the old rule, then minimum service shall be added to give advantage thereof. So Rule 5 Subclause 5 of the Rule 2013 as such can be said to be beneficial to such work charge employees whose service has been regularized subsequently. As per Rule 55, even if the minimum requirement of 10 years of service, that is qualifying service or pension, is not met, in that case also the service rendered as a birth charge to be added for qualifying service for pension. Therefore, the efforts have been made by the state government to see that after rendering service for a number of years as work charge and thereafter their service have been regularized, they may not be denied the pension on the ground that they have not completed the qualifying service for pension. It also further provides that the benefits like pension and gratuity shall be counted by giving 1 year advantage against the 5 year service as birth charge employee. Therefore, Rule 55 as observed is beneficial also in favor of such birth charge employees whose service have been regularized subsequently and they may not be deprived of the pension on the ground that they have not completed the qualifying service for pension. The denying of pension after rendering service as birth charge for a number of years on the ground that they have not completed the qualifying service can be said to be unfair and illegal and can be said to be exploitation. Therefore, to make such birth charge employees eligible for pension, Rule 55 provides that if any Barcharge employee whose service has been regularized under the Rule 2013 is short of qualifying service to the extent of such shortage of qualifying service, the service rendered as Barcharge to be counted for the purpose of qualifying service for pension. Under these circumstances, the larger bench of the High Court has rightly observed and held that for the purpose of pension, only such period from the birth chart tenure would be added for making the service of an employee who has been regularized to qualify him for pension. Insofar as the submission on behalf of the appellants that their entire service rendered as purchase should be considered and are counted for the purpose of pension, quantum of pension is concerned, the same cannot be accepted. If the same is accepted, in that case, it would tantamount to regularizing their service from the initial appointment as birth charge. As per the criteria of the decision of this court, there is always a difference and distinction between a regular employee appointed on a substantive post and a birth charge employee working under birth charge establishment. The birth charge employees are not appointed on a substantive post. They are not appointed after due process of selection and as per the recruitment rules. Therefore, the services rendered as birth charge cannot be counted for the purpose of pension, quantum of pension. However, at the same time, after rendering of service as birth charge for a number of years and thereafter, when their service has been regularized, they cannot be denied the pension on the ground that they have not completed the qualifying service for pension. That's why the service rendered as birth charge is to be counted and or considered for the purpose of qualifying service for pension, which is provided under Rule 55 of the Rule 2030. Now, insofar as the reliance placed upon the decision of this court in the case of Prem Singh by the learned counsel appearing on behalf of the appellants is concerned, the reliance placed upon the said decision is absolutely misplaced. In the said case, this court was considering the validity of Rule 3, Subclause 8 of the UP Retirement Benefit Rules 1961, under which the entire service rendered as birth charge was not to be counted for qualifying service for pension. To that, this court has observed and held that after rendering service as birth charge for a number of years in the government establishment department, denying them the pension on the ground that they have not completed the qualifying service for pension would be unjust, arbitrary, and illegal. Therefore, this court has observed and held that their service rendered as birth charge shall be considered counted for qualifying service. This court has not observed and held that the entire service rendered as birth charge shall be considered counted for the quantum of pension or pension. The decision of this court in the case of Prem Singh therefore would be therefore restricted to counting of service rendered as birth charge for qualifying service for pension. In view of the above and for the reason stated above, present appeals lack merits and the same deserve to be dismissed and are accordingly dismissed. It is observed and held that service rendered as birth charge after their service have been regularized under the regular scheme, namely Rule 2013, and circular shall be counted for the purpose of qualifying service for pension only, as per Rule 5, subclass 5 of the Rule 13. So, present appeals deserve to be dismissed and are accordingly dismissed. This was the bench of Justice M. R. Shah and Justice M. R. C. T. Ravi Kumar in the Supreme Court of India, New Delhi. And this case we decided one day back, 2 day back, that is on April 28, 2023. So in the end, I will say a lot of thanks for watching this video, and I would request you to become member of my channel so that you may get updates on the legal development in the near future. I am Ashok Arora, advocate from Chandigarh. Thank you for watching. God bless you all.